Welcome everyone to CBIA's HR Hotline Live. I'm Diane Mokriski, Employment Counsel here at CBIA, and I'm joined today by two very talented attorneys from Carmody Torrance Sandak Hennessey. We've got Nick Zaino and Vincent Farisello. Hi, Nick and Vincent.
Hi there.
Hi, Diane. How are you?
I'm good. So these guys are both partners at the firm. They're experts in employment law, and they routinely help employers, business owners, HR professionals comply with the seemingly endless supply of employment-related statutes and regulations out there. We know you guys in the audience think that the rules are endless. We do too, so we can empathize. But today's webinar, these are kind of fun for us, and I hope that they're fun or interesting for you in the audience as well. This is really your opportunity to ask direct questions of me and Vincent and Nick. And we're going to focus today's hotline on end of year issues, things that are particular to December or winter or end of year concerns, things like holiday parties, maybe employment of minors, if you've got students coming home from a break and are able to work. We'll talk about inclement weather closings, things like that. So if you have a question, put it in the Q&A function, please. We're going to use the chat for just talking amongst each other and for sending out written information to you all. We're not going to have any slides or anything today, but as topics come up, if we can think of links or documents that might be helpful for you, we'll put those in the chat. So I know I did say this was your opportunity to ask questions. I lied just a little bit because we're actually going to start with us asking you a question. So if we could put our polling question on the screen. And so that is, do you anticipate changing your emergency closings policy to either allow or require remote work rather than closing your facility in its entirety? And this has come up, as you may have imagined, because we've all seen, mostly maybe because of COVID, that you all have implemented more robust remote work policies. And so we're kind of wondering, if you have to close for bad weather or for some other reason, are you going to have your workers, are you actually just going to close? And we'll talk about how that affects how you pay people, or will you have people work remotely? And so if you all could just give us a couple words in response to that. And while you're doing that, let's talk about some of the wage and hour issues that come up as a result. So let's talk first about exempt employees that typically get the same paycheck every week. And let's say it's terrible weather and the employer closes for the day. How should an employer handle that from a pay point of view?
Dan, I'll jump in on that one. I know you started with the concept asking about exempt, but I'll actually go a little bit before that. We'll start with non-exempt because that one's a little easier. And the answer there is pretty simple, that an employer is really only obligated to pay a non-exempt employee for actual hours worked. So if the facility is closed or the employee just can't make it in, there's no obligation to pay. It's a little bit more complicated when you're talking about exempt employees, because most exempt employees are subject to that salary basis test, which, as you alluded to, requires payment of a predetermined salary, each week, regardless of the quality or quantity of work. So that general rule means that if an employee works any portion of the week, in general, the employer must pay them for that whole week. With some very limited exceptions to that. And the employer choosing to close for that day is not one of those approved exceptions. The typical exceptions are, the beginning or the ending weeks of employment. Obviously, you don't have to pay a full week there. There's a few others, like one or more full days if the employee is absent for personal reasons other than sickness or accident. So, If it's the employer who's closing, that one doesn't qualify either. If for absences of 1 full day due to FMLA, or in very limited circumstances for disciplinary suspensions for violating safety rules. That one's pretty particular to Connecticut. But the DOL is pretty clear that if the facility is closed for a day due to a lack of work, due to our operating requirements, and that would likely be the case here if we're choosing not to open, that is not one of the exceptions. So for the exempt employers, generally, if you're choosing to close, you're going to have to pay the exempt employees for that time. So, to your point, though, it's better to, get out in front of that, anticipate some of that. So I generally recommend if you're the type of employer who considers closing, I do think it's a good idea to think about that and do have a policy in place. One of the most common types of policies is something along the lines of, hey, if we choose to close, it's our call to close, we're going to pay folks. If we're open and you choose not to come in, then it's either going to be unpaid or we're going to require you to use a PTO day. That's a pretty common variation of that policy. I've also seen some that differentiate between exempt and non-exempt employees. For some employers that might work. My caution on that is, to be mindful of the impact on morale when you're differentiating between folks, especially between exempt and non-exempt. And, does it create a greater schism between the two classes of employees? It's certainly possible to do, especially since, as I started by saying, the law treats exempt and non-exempt differently for this purpose, but certainly doesn't mean you can't treat them the same, as long as you be mindful of those exempt rules on the salary basis test.
Okay, and I know, so the Connecticut Department of Labor has kind of taken a really strict view of that PTO issue. Nick, do you want to talk a little bit about that?
Yeah, so it's a great question. Somebody actually put in the Q&A the exact question that we sort of anticipated, Diane. Somebody asked, can you require an exempt employee to use PTO if you close for the day? And the DOL did address that in an FAQ, as you said, and their position is that it's not permissible for an employer to require an exempt employee to use PTO if the employer chooses to close for a particular day. I think that's a different view than the Federal Department of Labor or the Federal Wage and Hour Division has taken, but that is the Connecticut DOL's view. So in that situation, you would have to pay the exempt employee, their full salary for that week and could not make a deduction or require them to use PTO. Then that leads to the question, what do you do with your non-exempts? Are you then going to pay them for the day that you chose to close? And as Vincent said, I think most employers do that. But from a legal standpoint, you are not required for your non-exempt employees because they're not working.
Right. Okay. All right. And so let's take a look at the poll results.
And folks, if you have thoughts on, here's what I'm curious about, and I think it would be helpful for you all to hear from each other. Like for those of you, you could just put your comments in the Q&A or in the chat box and we'll look at them as we look at the poll results. But I'm curious if you have a hybrid. Let's assume you have some employees who come to the office on a particular day, particular days, and some employees who work remote. What do you do in the situation where you close the office and those employees who are supposed to be at work that day, don't have to come into work because you closed? Are they then going to be working remote? Or are you going to, what would your policy be in the situation where you have a hybrid workforce, where they come in some days of the week and some that don't come in? And so there are all different permutations now that a lot of employers are having employees work remotely, from full remote work to remote work for some employees, not others, to hybrid schedules. So I'd be curious if others, and I'd see there's a bunch of things coming in about policies and what changes you might have made.
Yeah, so I mean, you mentioned a morale issue. If you, let's say, let's say when we're talking about hybrid policies, that you've got some employees who are able to work from home because they tend to work from home anyway. And then you've got employees who can't work from home. That's just not possible through their job. I mean, I don't really see a discrimination issue there, right? If you had a rule where you said, hey, if you have all the equipment you need to work, you have to work this day. If you don't have that equipment to work, then you obviously can't work. I mean, so do you think that is more of just people are going to think that that's unfair, but what are you going to do type of thing?
Probably more of a morale issue than it is a legal issue, it seems to me. Like the person who is home expected to work when there's others who are getting a paid day off because it's a snow day may feel like, hey, that's fair. You know, we had 4 paid snow days that some employees got really as extra PTO days. They got full pay and we had to work. Conversely, if you don't pay those employees, they might, who are non-exempt, right? You choose, look, you didn't come into work, we closed, I know, but we're not going to pay you. They might feel it's unfair that they got essentially a pay cut for the year while other employees were allowed to work from home. So no matter which path you take, there's the potential for some morale issues because some employees who are exempt will be required to work or will be paid. And then if you have anything different for your non-exempts, you're going to run into a morale issue or potential morale issue.
Right.
One other sort of legal issue that I suppose can come up is if you're not keen on the work from home, there are some employers who aren't, but then you allow or require it during an inclement weather situation, and then an employee who can do some work from home requests to do that as, for example, part of an accommodation for a disability. It might impact your ability to, deny that as part of the interactive process that you may or may not be engaging in as with someone for a disability. So that's one legal type issue that can come up with it.
Yeah, so let's dive into that a little bit. We do have a question come in, but before we get to that, Vincent, since you brought it up, so you're saying that if you're requiring or allowing people to work from home because it's a snow day, then does that mean at some other point you have someone totally unrelated to the office closing, but you have someone who has some sort of medical issue and their doctor says, working from home would be a way that would help this person? Do you think that the employer then has to grant that accommodation because it's something that they allowed people to do when it was winter?
Yeah, I don't think it's automatic, yes, that they must allow them to do it, but I think it certainly becomes part of that analysis, because if that's an accommodation that's requested, they can perform the essential functions of the job. The employer's put in a position of having to then say, no, I can't do that because it's causing some undue hardship on the business, right? That's going to be the most common pushback from the employer. And so, it's possible that the fact that you allowed it to happen in those other circumstances is evidence that no, it won't cause an undue hardship. Certainly the employer can, depending on the facts and circumstances, might argue otherwise. Well, yeah, sure, we can do that on a very limited temporary basis, but not on an indefinite basis. But I just think it just complicates that whole interactive process analysis.
Yeah. Nick, do you have anything to add to that?
Yeah, I would totally agree. It's not automatic. It is an argument. An employee might say, look, you did it in the winter. Why can't you do it now? And I think Vincent's right. It can be distinguished. Like, look, we did it in the winter for 1 day or 2 days. The accommodation you're asking for is for 2 months or indefinite, and that's very different. And so it doesn't mean it's automatic, but it opens up that analysis a little bit because the employer did do it at one point. And, it doesn't mean you're bound to it all the time, but I think it opens up that argument.
Okay.
So
All right, so the question that came in that you can see in the Q&A has to do with tracking salaried employees. And let's just assume that this person means exempt. And so everyone out there, this is such a common issue. I feel like I'm always saying to people, salary doesn't mean exempt. So when you're describing someone to me as salaried, I assume you mean exempt, right? And so This person is saying, can you track an exempt employee's sick days or the amount of hours they take off when they have a doctor's note? And so what do you gentlemen have to say about that?
Well, I think it makes sense to certainly track that. It does impinge on that salary basis test that I was talking about before. You know, you kind of go back to that general rule of having to pay the full week for any week in which work is performed. But I had mentioned there are some exceptions. One of them is for one or more full days of sickness or disability. Only if that deduction is made in keeping with the company's bona fide plan or policy or practice of making deductions from salary. And again, those one or more full day increments after the sick time has been exhausted. So while the employee has sick time, you can certainly apply the portion of the day or week that qualifies for sick time. You can take it from that bank. But once the sick time is exhausted, you can do the deductions, but only for full days missed, not for partial days or just an appointment for part of the day or an hour or so. And you want to make sure that that's clearly laid out in your sick time or PTO policy.
Yeah, so everyone understands that. So I guess that's, first of all, the answer is yes, it would be a good idea to track those hours, right? But if you have an exempt employee who uses up all their PTO and then they go to a doctor's appointment, it kind of doesn't matter, because even though they've used up their PTO, you still can't reduce their paycheck for that portion of a day. Do you agree with that?
Yes, there's no partial day deductions. And so once they exhaust the sick time and they go to a doctor's appointment for 3 hours in the morning and then they're back at work, there's nothing further to deduct. Remember, the exempt employee typically doesn't have a fixed work schedule. I know there are probably some employers that do require that. And where we've seen that is where an exempt employee's physical presence is necessary. So take, for example, a retail establishment, and say you have a store manager. And it's just necessary for that store manager to be there 1 hour before opening and 1 hour after closing. Like, they literally need to be on site in that store. So in that case, that employee has a fixed work schedule. It's easier to track when they're not there, right? So you can track when, you can track partial days that they're out for sickness, but you just can't deduct from salary. So that might be an attendance issue. That might be, you're not there, like you've exceeded all your sick time, and there's a performance issue that needs to be addressed, but you can't deduct from their salary for a partial day absence.
Right. All right. And so then this question about paying people when you close for bad weather is, if you have to pay them, wouldn't that push the employer to stay open during dangerous weather? So
yeah, that's one where you don't let the sort of tail wag the dog. Remember, the biggest liability is kind of compelling employees to get on the road when the state's closed, when it really is dangerous for people to be driving. And I think the employer from a moral standpoint doesn't want their employees getting in a car, driving, trying to come to work during weather that it really shouldn't be driving. And you also don't want to open up the risk that somebody gets hurt driving to work because they felt compelled to come to work in dangerous weather. So make that decision first and foremost in your hierarchy of decision making, and then worry about the wage and hour issues sort of second. Don't let the wage and hour issues drive a safety decision.
Right.
I think that's good advice. All right, so let's move on from weather closings. If people have more questions about weather closings, that's fine, we'll answer those. But let's move on to students coming home during school break. The Labor Department's got lots of rules about employment of minors. And we're going to put some links up in the chat, just so, because these rules are pretty complicated. And so for those of you attending, you can take a look at these links when the webinar is over. But just so you know, there's one set of rules for 14 and 15-year-olds, and then there's a whole separate set of rules for 16 and 17-year-olds. And then there's another list of rules that just says you can't do this ever for any minor, right? Nick, we were talking earlier before the webinar started about that 14 and 15-year-old issue that for those really young students. Can you say generally speaking what the rule is for those guys?
Yeah, so and I would encourage you all to, if you are employing any minors, that's anyone under 18 or 14 to 17, do go to the DOL website. It's actually quite good and it's easy to follow, easy to read. And Diane's right, they have a separate link for 14 and 15-year-olds, and they have another link for 16 and 17-year-olds. And they lay out the occupations that are permitted for 14 and 15-year-olds. And it's narrow, like, they're not allowed to do just anything. There's a list on the DOL website of the occupations that minors who are 14 and 15, the different types of jobs that they're allowed to work in. And I'm not going to go ahead and read the whole list to you, but it's on that DOL website. And then the DOL website also has, for 14 and 15-year-olds, restrictions on the hours of work that they can work only when school is not in session. So 14 and 15-year-olds can only work when school is not in session. And what that means is 5 consecutive days or more where school is not in session. And there are hours limitations. They cannot work more than 40 hours in that week or more than 8 hours during the day. So that's 14 and 15-year-olds. For 16 and 17-year-olds, the list is a little different. In other words, the presumption is they can work in any job unless it's prohibited. And so the DOL website has a list of prohibited occupations in which 16 and 17-year-olds cannot work. But if they're not on that list of prohibited occupations or tasks, then the 16 and 17-year-olds are permitted to work. There are hours limitations for them as well. And it depends a little bit. It's a little more complicated to try to get into here. You really do need to go on the website, but the hours limitations depends on whether they're working in a restaurant or a recreational or amusement or theater, manufacturing or mechanical. And so they break the hours limitations down a little bit by industry. So if you have 16 or 17-year-olds, you really do need to look at that DOL website to determine the hours limitations.
Yeah, and those are both now in the chat. We've got one link for the 14 and 15-year-olds and one for the 16 and 17. So keep in mind, we did have some members wanting to employ people during the Thanksgiving break, for a 14-year-old actually. And so it's just important to remember that they cannot work over Thanksgiving break unless they had 5 full days off from school. So that's important to remember. That's only for the 14 and 15-year-olds. And with that one exception, Nick, right? There was one place you can work on Saturdays.
Yes, and that's
I have that in front.
I think it's a retail establishment.
Yeah, retail food store. A 14 and 15-year-old can work in a retail food store on Saturdays, even if it's a short break. But other than that, you've got to have a nice long break for those younger workers, or they can't work at all. And now I can feel my voice going. I warned everyone ahead of time that I had a cold, and so just bear with me. I may be losing my voice a little bit. All right, so let's go back to that's the employment of minors. We've got a question about paid internships. Does a paid internship constitute a full-time employee? Vincent, do you want to tackle that?
Yeah, sure. I guess I'm not sure I understand exactly what in the context of full-time, what's meant there, but a paid internship is generally needs to be treated like an employee, and you need to provide them with all of the same protections, and they'll still have coverage for workers' compensation. They'll still be paid. Payroll taxes will be withheld and paid over. Unemployment will pay into unemployment on their behalf. With regard, the sticky thing is some of the benefits. Presuming that the paid internship is of temporary duration, it's certainly possible in most contexts to exclude them from paid time off type benefits in most contexts for those that are provided by the employer. With regard to things like insurance or other, third-party provided type benefits, it may depend on the plan documents themselves. Oftentimes, temporary workers are generally excluded from are generally excluded from many of those benefits. But the same wage and hour rules apply. Everything else kind of applies.
Yeah, there really isn't a universally defined or definition of full-time. I think Vincent's right. It just depends on the context in which you're discussing it. And what's more important is how many hours do they work? Do they work enough to qualify for benefits? Do they work enough to qualify for overtime? They accrue sick time under Connecticut's paid sick leave. So the word full-time is nebulous. Like there's not a law that says this is what constitutes full-time for all purposes.
Right.
Right. And so I'm going to go back to a question we just want to clarify, and that's what the question says, just to clarify, having to do with docking pay. So if an exempt employee comes in for an hour and then leaves for the rest of the day for an appointment, can the employer ask them to use PTO? And I think what we were trying to make clear is that you can ask them to use PTO, yes. What you cannot do is dock their actual paycheck. Is that
correct? Once they exhaust their PTO,
right,
you then cannot dock for a partial day absence. So you can require them to use PTO to round out the day, but you can't. And again, that gets, that's easier said than done sometimes. That's easy to do when the exempt employee is supposed to work from, this time to this time, or 8 hours and they only work 6. You can say you've got to apply 2 hours of PTO, but in many circumstances, the employers, for exempt employees, there is no fixed schedule. The exempt employee is truly just allowed to, work their own schedule as long as they get the work done. That's sort of the impetus for an exempt employee. And so it's easier said than done. But if you do have a situation where it's a fixed schedule for an exempt employee and they work 6 out of 8 hours, you can require them to use 2 hours of PTO to round out that day. But Diane's right. Once they exhaust, it becomes a disciplinary issue, perhaps, not a deduction that you can take for a partial day.
Yeah, you could, one thing that could change that is if the person is exhausted all PTO and they take the entire day off for a personal reason, that could justify or, qualify as an exception for docking the full day of pay, but it's got to be in a full day increment and it's personal other than due to sickness or illness. If it is full day sickness or illness, you're back to it depending on what your policy says, as I kind of outlined earlier.
So that's a reason for everyone to try to maybe put on your list of things to do. Take a look at your policy regarding PTO. I get asked all the time for sample PTO policies, and it just does not work. You've got to have a policy that's tailored to the way that you actually enforce your PTO, right? So everyone take a look at their policy and decide how you want to enforce it. Are you going to dock and exempt employees PTO bank for partial days, or are you just going to pay them the same because they're exempt? You kind of have to decide and tailor your policy, and you can contact Nick, Vincent, or I for help with that if you need it.
Just one quick piggyback on that, Diane, because I'm chuckling in my head. I've said this many times to employers before when I'm doing a full employee handbook review, the PTO or whether it's a single bucket or multiple buckets, that's usually the policy or policies that I wind up spending more time than the others on, because it's just so unique. It's so specific to the organization, and they're so different from employer to employer.
Yeah.
Oh yeah, A+ to employers for creativity on some of the PTO policies.
Yeah. The ones that allow, 3.14 hours for every 5.3 hours worked, I love those. All right, so let's move on to, this is a bummer of a topic, but we said we'd talk about it. So is an employer liable if an employee is injured in a car accident, or let's say injured someone else in a car accident because they're intoxicated after leaving a company function that served alcohol. Whoever wants to take that, jump on it.
Yeah, so I think with any company-sponsored event, right? So company-sponsored, and that in and of itself becomes a question: is it a company-sponsored event? But let's assume it is for a moment. Anytime there's a company-sponsored event and there's alcohol served, or not, but you own what happens at that event, right? That company-sponsored event is no different than you calling all the employees into your conference room and something happens in that conference room. If you have a company-sponsored event and something happens at the event, then you have potential liability for what happened at your event. You're talking here, the question here is about an employee who goes to a company-sponsored event, alcohol is served, and then on their way home, or they're on their way someplace else, they get into an accident. Is the employer liable? Well, not automatically, right? It depends on what happened. What are the facts and circumstances? And was the employer negligent in some way in allowing that employee to drive home, perhaps because that employee was clearly intoxicated or known to be intoxicated by others at that event? And so it just depends on the circumstances. If it's one of these situations where everyone knew, it was obvious this person was intoxicated, the employer knew or management knew that the person was intoxicated, yet let the employee get in the car and drive home, then yes, there's a greater chance of liability for the employer, that the employer was negligent. The employer had a duty to the employee and to other people on the road who that employee driving home may have impacted, to not have allowed that employee to leave. But if the situation is such that the employer took every reasonable precaution at their event, maybe they limited the service of alcohol, they limited the type of alcohol, they limited, how much alcohol employees can consume. Maybe it's at a place where there are professional servers who didn't work for the employer, and there was no sign that the employee was intoxicated, but you know what? There was no visible sign, nobody knew it, but they failed a field sobriety test, or they failed, and got in an accident. In that case, would the employer be liable? Not necessarily, because the employer didn't know. So it really depends on the facts and circumstances in determining liability. But anytime you serve alcohol, yeah, there's risk for sure.
Yeah, so the fact that the answer is maybe is really enough, I think, for an employer to take as many precautions as possible. So Vincent, do you have any, are there any, Nick mentioned maybe having a professional server who can maybe better at determining whether someone's had too much to drink. Are there any other tricks that you can think of that an employer could use to maybe lessen the likelihood that they'd be liable?
Yeah, and one that just came to mind is offering 1 or 2 drink tickets or tokens or something, as opposed to a full open bar. But you could kind of mitigate some of that risk with an open bar by making sure that it is by doing it at a facility. The facility itself has some responsibility in that case, or hiring a professional service to come in. That's one of the ones that I see that's most common. Nick mentioned the other 2, which is kind of trying to limit to beer and wine. Not foolproof. There's just a little bit more risk when you're talking hard alcohol. But yeah, those are kind of the most common, I think. I just think again, the best thing is to, you're a manufacturing company out there, or a law office, or you fill in the blank. You're not an expert in serving and necessarily identifying that kind of risk. And so
Yeah.
I think using a third-party provider is probably among the best things you can do.
And Nick, were you gonna add something?
Oh yeah, I just think other things that some employers have done, again, to minimize risk. One, don't have alcohol, obviously. Cut alcohol off at least an hour or 90 minutes before the event is scheduled to be completed. Some employers don't do it at night, they do it during the day. They have the holiday party during the day, where there's, people are less likely to maybe drink too much if it's done just during the middle of the day. But I think that, I mean, and nothing is foolproof, as Vincent said, even if you do the ticket, everybody's been to these where somebody's like, I'm not drinking, do you want my 2 tickets? And suddenly somebody's, amassed a full dozen tickets. But the more you can do, the more that you can show that you've taken steps to mitigate risk and have actually mitigated risk by doing that, the better off you are.
And having food
Food,
be
yeah.
as much a focus of the event as the alcohol. Maybe reminding folks about expectations and conduct. And one thing, I know even we do here is providing transportation, perhaps.
Right. All right, so on a related issue, rather than talking about, there is potential liability for car accidents. What about, I mean, this is just so common. What about the increased risk of sexual harassment? And Nick, you mentioned, you started out in your answer earlier, you said, an employer-sponsored event.
Right.
So can you talk a little bit about what would be a scenario that maybe would not be an employer-sponsored event, and then what would, like, how do you tell?
Yeah, so it's obviously the analysis is an entire progression. So start with an easy one, right? 2 employees, the workday's over, 2 employees decide they're coworkers. It's been a long day, it's been a long week on their own without any management, any supervisory attendance. They just decide on their own to go to a bar down the street, grab a drink, and maybe they drink too much. Something happens at the bar or something happens on their way home. Is that a company sponsored event? Clearly not, right? 2 employees totally on their own deciding to go to a bar down the street, not something the company sponsored. And then let's do an obvious company sponsored is the one that we're talking about pretty much, a holiday party that the company actually puts on, even if it doesn't mandate that employees attend. In fact, they're usually voluntary, they're not mandatory, but it's one that the company's paying for, management's going to be there, they really would like, good attendance. That is clearly a company sponsored event. And then there's everything in between, right? There's everything like, all right, maybe it is a group of employees who decide they want to get together at the end of the week and they invite their supervisor to go, and the supervisor says, oh yeah, I'd love to go. And maybe the supervisor, when they go, they pick up the tab, and maybe the supervisor also invites one of their supervisory people. So now you've got a couple of management folks there. Does that become a company sponsored event when you have management there? So how was the event organized? Did the employees organize the event on company time? Did they print invitations, on the company's printers? Who was asked to attend? Who was present? All that stuff matters in figuring out if it's a company sponsored event. What we tell our supervisors when we do training and managers is that if you're there, assume it is. Just assume it is. If you're management and you're present, assume that that is considered part of the workplace, and apply the same workplace rules as you would if it was happening literally on site in the physical building of the employer.
Yeah, so if you're a manager and you're at a bar and you're with a whole group of your employees, and you see one of your employees getting inappropriate or sexually harassing one of the other employees, there's a duty there, you think, to step in?
I think so. I think, putting aside a legal duty, I'm going to use just regular duty. I do think it is prudent for that manager to step in. So somebody tells a really inappropriate joke or makes a really inappropriate comment, or somebody improperly touches somebody at that event and you're there, you're a manager, you should address that and not say, well, everything goes, we're off site, we're at a bar, so, the definition of what is a company sponsored event depends on the facts and circumstances, obviously. So, but yeah, there's an increased risk of harassment. People are in a casual setting. Typically, it's not work's not being performed. The whole point of a holiday party is for people to just sort of mingle, and you add alcohol, and maybe you add dancing and music, and suddenly, the normal professional lines start getting blurred a little bit, and there's a risk of, certainly an increased risk of harassment, discrimination, or other inappropriate things being said or done at those events.
So what do you all think about, this is just tangentially related, but that holiday party, what do you think about employees taking photos with their iPhones and just taking photos of each other, posting them on their social media. We've got a couple issues there. Which one of you would like to tackle that?
I'm going to tackle that one. So go ahead, Vince. I'll let you tackle.
Yeah, listen, we're in such a different world than we were 10 years ago, 20 years ago. I mean, everybody's got a smartphone. People are constantly taking pictures. What are you left with? Trying to say, instituting a rule that says thou must not take pictures and post them. I get why an employer might want to do that. I would just caution that there's always some risk when you're going to try to limit an employee from recording or taking pictures of something that an organization like the NLRB, the National Labor Relations Board, which the NLRB enforces the NLRA, the National Labor Relations Act, which does not only just apply to union shops, it applies to non-union shops too, to the extent that it's there to allow employees to engage in concerted activity. It makes that kind of activity protected if it's done to in connection with the employees working together regarding their terms and conditions of employment. So when you're saying you can't take a picture at the holiday party, there's some risk that could on its face violate that protected concerted activity rule in the NLRA. So I'm not sure that it would be effective or a great idea to outright ban phones or taking pictures at all. I do think what you could do is certainly instruct employees that they shouldn't take pictures or record their coworkers without their consent. That's a reasonable instruction to make. Same thing, remind folks that, hey, not everyone may want to be on social media. So if you're going to do something like that, you really need to get those folks consent, because you don't want to violate their sense of privacy. One thing, I know we've done this before, which I think is also a good idea. You can also think about hiring or designating someone to be sort of like the photographer for the event. Because I think what will generally happen is folks will go to that photographer and ask them to take the picture. And then that kind of designated photographer, they're in a better position then to kind of, control what's being documented or not. Not foolproof, of course, because may not necessarily be able to stop people from having their phone. But at least they can help police it a little bit. Like if, for example, there's a concern about, we don't want the internet, Facebook flooded with pictures of folks holding martinis here, a designated photographer type could say, hey, great shot, can we put the drinks down? Again, may not always work, but it's one way of being able to try to manage that content, what gets posted, without necessarily, being over the top or heavy-handed.
Mm-hmm. Nick, do you have anything you wanted to add to that?
I'll just give you just a little bit on why the NLRB cares, right? Why does the NLRB, how could the NLRB find that it's a violation of the act for an employer to prohibit outright for employees from taking pictures? Let's assume for a minute that you have an employee who many employees have complained about, maybe it's a manager, that this manager says things that are harassing or that are discriminatory based on gender, right? And the employees are frustrated that management hasn't done enough to address this manager's behavior at work. And so now let's go to the holiday party where the manager is present. Maybe the manager's had a little bit too much to drink and the manager is there acting up again, right? And he's doing it, or she's doing it in an obvious way. And the employee who is there, who's frustrated that the company hasn't taken enough action, wants to record that and wants to take a picture of the behavior, or maybe a little video snippet of the behavior that they're witnessing happening at that holiday party. And they're doing that because they want to document that it's continuing and it's continuing to happen at this holiday party. And they post that on let's say I don't know, all the different social media outlets, but let's assume it's Facebook, and they're talking to other employees about this happening again at work at the holiday party. Did you see what happened? Look at this little video. The other employees, part of that group, chimes in, says, yeah, I saw that, I can't believe it. This behavior continues. And the employer gets wind of that, and say it takes disciplinary action and says, look, we told you no pictures. That person files an NLRB complaint saying, I put the picture up there, I was talking to other employees, and we're doing that to engage in this protected activity, documenting the inappropriate behavior that's happening in the workplace in this company-sponsored event. The NLRB would likely find that that policy and the discipline of the employee are both unlawful under the Act. So that's what I think the NLRB is trying to protect. And so, but I agree with the general advice that you want to appeal to people's reasonableness, that they not post things on social media without the folks who are on that picture or little video clips consent. Because that is just, that could very well be an invasion of their personal privacy, depending on what's being depicted, and hopefully people are reasonable. But that's
and that scenario that you laid out with the person posting on social media and the NLRB not approving of the termination as a result, that would apply to even a non-unionized workplace.
Yeah,
Right.
Exactly, because the act protects the right of employees to engage in concerted protected activity, and that applies whether the employer is unionized or not. That provision is what allows employees to form a union, right? That behavior that I was describing, where something bad is happening at work and the company is not taking action, that's what the NLRA is all about. It allows employees to kind of band together to say, look, the employer's not taking this seriously. We need to do something. We need to form a union. Like that's the whole purpose and intent of the NLRA. So that would apply whether you actually have a union or not. So yes.
Okay.
Yeah.
All right, Vincent, it's my understanding you are an expert in the following topic. So are you ready? I have gotten a lot of questions about regular rate. And if you pay an employee a end of the year bonus, how does that impact their overtime rate and their regular rate? And can you just give them the bonus in cash? And because you already paid them overtime for the overtime they worked during the course of the year, can you leave it at that?
Yeah, it's a good question. So you mentioned regular rate and comes up in the context of overtime. And overtime is, as I hope most folks remember, is not purely a function of just what the person's regular base hourly rate is times 1.5. The phrase that's used is quote unquote regular rate. And so, for example, that could include more than, the regular rate includes all remuneration pay that the person received for that pay period. That's how you figure out, and you divvy that between the total number of hours worked, and that's what you get as the regular rate. And that's the rate that should be used for figuring out the halftime premium that's owed over 40 hours. So, but how end of year bonuses could get into that is, to the extent that the bonus that's being provided is not discretionary in nature, if it's based on some objective criteria that covers, a certain period of time, then arguably that bonus theoretically should be recalculated into the regular rate that employees worked for that period of time, which could cover more, multiple pay periods, an entire year. It might, when you extrapolate out the numbers, it might just be a very small, minuscule amount of back overtime that's due. But the point is, to the extent it relates to a period of time and it's objective, not discretionary, then it could, the employer could be under an obligation to have to add it back into the overtime that was earned during that period of time. On the other hand, if you have a purely discretionary holiday end of year bonus that's not based on any criteria or, that's not that the employer at the end of the day can simply choose not to do, there's no obligation to provide it, that does not need to be recalculated or applied to regular rate at all.
All right, and so we've put in the chat a fact sheet 56A from the Department of Labor. Nick, if you have any summary type information that you have, that would be helpful, but for everyone, just so you understand in the audience, so 56A is pretty detailed. It's a long description of all the different scenarios where you might change a rate of pay because of a bonus. So take a look at that. But Nick, do you have some general guidelines on that?
General comments, and I think Vincent explained it well. You know, if you have a bonus that the employee expects, it's not purely discretionary, and that employee is non-exempt, and that employee has worked overtime during the period in which that bonus was earned. When you pay that bonus, you have to have a little bit of an overtime adjustment for that, right? That's, you know, you have to take that bonus amount and factor that back into the regular rate calculation. And so without getting into math right now, what I do want to point out is the additional compensation that you're going to pay is small, typically, unless you're talking huge bonuses, but it's typically not the case with non-exempt workers. But so you might be saying, well, that's such a small risk, right? It's just, let's say it's a $2,000 bonus. And if you include it back into the regular rate, it's $100. So instead of being a $2,000 bonus, it would be a $2,100 bonus. That's a small amount. I'll just take that risk. The problem with that is if you have, let's say you have a manufacturing company and you give an annual bonus to 50 employees of some amount, and you don't factor in the regular rate, you don't factor in that bonus amount into the regular rate and pay the overtime adjustment. You've got 50 violations for those employees. Multiply that by potentially 3 years of current and former employees. And suddenly the risk becomes much, much bigger. And so we have seen, I mean, it is often the case, unfortunately, that employers don't understand regular rate. And the regular rate concept is really intended to encompass all the compensation that employees get for the services that they perform. So for example, an employer can't just say, well, I'm going to pay a minimum wage as an hourly rate, but you can earn this, and you can earn this, and you can earn this, and you can earn this. But when I pay you overtime, I'm only going to pay you overtime on the minimum wage, the hourly rate that I'm agreeing to pay you. That would be a violation of regular rate. Regular rate is intended to encompass all the compensation that the employee got. So even if the amount is little, you know, think about how many employees are impacted by it. Think about the number of years of current and former employees who've come and gone, and suddenly that risk is not that small. So be careful about regular rate with annual bonuses.
Okay. All right. So one issue that the Labor Department has pointed out as being a problem this time of year when retail is super busy has to do with the employers not accurately calculating hours. So for example, how does an employer handle it if they require an employee to come in and do some sort of prep before they start, like a cashier, there's something they have to do to their machine before they actually start, or there's some sort of like closing up duties that they do. When does their time, like what are the time duties and the payment duties for the employer in that situation? Do you know what I'm saying? Like they have their set hours, but there's prep and there's closing, and what do they have to get paid for?
Yeah, preliminary and post-preliminary work that's done. You know, I think the standard is, just off the top of my head, if it's necessary and indispensable to the work that they do, then that preliminary work must be compensated as if it's regular work time. So trying to think of a good example. This comes up a lot with donning and doffing, you know, if somebody works in a facility where, you know, there's a safety issue, maybe it's a food service establishment and they need to actually, or just a facility manufacturing where they're processing food and they have to wear certain clothing, that is likely compensable time. Or if they need to take some action before they actually start the day, like there's sort of a retail establishment, there must be a walkthrough that you need to do just to make sure that everything is in order, and then they can start their day. That walkthrough is necessary and indispensable to the work that they do. Security checks, I believe, have been determined not to be necessary and indispensable. So that means like a retail establishment that before the employee leaves at the end of the day, they go through a security check just to make sure they didn't steal anything. That wouldn't be necessary and indispensable for them to do their job. So there's an entire standard. What I would say, again, this is one of these where you're talking minutes. And it sounds, and it's small. It is small from a monetary standpoint, typically. But if you violate the law, it could be huge because the penalties and the potential exposure over a number of employees over a number of years can suddenly pile up. Yeah. So err on the side of I would err on the side of paying unless it's clear that you're not obligated to pay.
Yeah, and in the circumstance or the scenario you were talking about, Diane, it certainly sounds like those things would be integral and indispensable to that person doing the job. But getting the register set up and because they're required to do that by the employer in order for them to do the job. If it's getting inventory together, if it's a clothing store, the store's closed and you need to go around and fold everything and put it back so it's all orderly. That all certainly sounds like it would be compensable to me.
All right, so I'll leave it to you guys to decide who wants to answer this, going back to social media. If you can see that, does the ultimate question, is there any recourse for the business? Do you one of you want to read through that and give an opinion?
I think the racial slurs goes over the top, and it's something the NLRB would not protect if somebody makes racial slurs, even on social media. And so in that situation, I think the employer would be on much better footing to take action against the employee for making, especially if those statements are directed at specific employees, which is how I initially was reading this. And then I see.
Yeah, no, I think they're saying saying on their posting that someone else is using racial slurs. And so you've got an employee who's posting on the internet that coworkers are racist. And so this is like a problem for the employer to have this reputation now online. And it's causing an uncomfortable work environment. So what would the business do in that situation?
Yeah. We want to have a conversation with this person. Like, I think it's kind of tough to just give good advice. I mean, typically what you would say is meet with this employee and have the employee come to you and not go to social media. Like, encourage the employee to bring the concerns to you and give you an opportunity to address it rather than go on social media. But you'd want to know the whole full context of this, this particular situation. I don't know, Vince, you have any other thoughts on it?
Part of it is context too. Is this in the context of concerted activity? That's the key. Is this for the purpose of working with coworkers to bring this issue to light or to try to address this issue? Or is it on the other hand, just going off, spouting off, just to, just out into the ether, not, sort of not within the context of, of concerted activity working with others. I remember, in the, during the Obama administration, the NLRB dealt with a case where an employee went on social media, I think it was in the context of a bar or restaurant, and started, just making really negative, nasty comments about a patron of the place. And the NLRB in that context said that it was not protected because it wasn't done in the context of working with coworkers in a concerted fashion to address issues related to terms and conditions of employment.
Yeah, and so if the employee who's posting this online is really concerned that a coworker is making racist comments, then that's really, I would say, something that should be handled through your complaint procedure, right? Like a hostile work environment or harassment complaint procedure. And rather than, you wouldn't want to punish that person, right, necessarily.
Yeah.
But like you said, the two of you,
right.
Encouraging them to do that through the appropriate channels is really the way to go. So we are at the end. There is one question that we didn't hit, and I'm gonna, unless one of you thinks you can answer this in a minute, I'll give you that opportunity if you think you can, but this is a little bit complicated. I would encourage this writer to contact Nick or Vin separately. It has to do with unemployment benefits for remote workers living in other states. It's a little complicated. You want to leave that for another conversation? It's common. I understand it's a common question. It's something that needs to be addressed, but we're at the end actually. And so I guess maybe I'll just encourage that anonymous writer to reach out to Nick and Vincent. That's something that we do get a lot of questions on. And so I'll leave that for that.
Yeah, that probably makes sense. My gut tells me it's in each state, but
Yeah,
if they're working remote in each of the 20 different states, they'd file in their respective state. And the unemployment division coordinates all that.
so that's the tickler for the person who wrote that.
Yes.
So thank you everyone for joining us. This was great. Good luck everyone with your holiday parties and with figuring out your end of year wages. This hotline, this is something we do quarterly. So we'll see you again, I believe, in February, the three of us again. And so have a good day, everybody. And thanks for joining us. And thanks, Nick and Vincent.
Our pleasure. Happy holidays, everyone.
Thank you.